now joining the meeting.
Jennifer, have a good afternoon.
You as well.
All right. Good afternoon, everyone. My name is Judge Gilson, and with me on this panel is Judge Moynihan and Judge Coomer. We'll be hearing the matter of the estate of Todd Harris Applebaum. This is docket number A-3948-18T3. How many counsel will be presenting arguments? As I see it, there's going to be 3. Is that correct?
I believe that's correct, Your Honor.
All right. Let's take appearances, beginning with the counsel for appellant.
Good afternoon, Judge. Mr. Santos A. Perez on behalf of the appellant, 𝒖𝒏 Applebaum.
All right. Good afternoon. And for respondent, William Fabian.
Good afternoon, Your Honors. This is Thomas Howard of Howard Law, attorneys for William Fabian, the executor of the estate of Todd Harris Applebaum.
All right. And then there's respondent, Rasha, is it?
Believe it or not, it's Rice.
Right. Okay. Well, thank you for that clarification.
My name is Ron Israel from the law firm of �ခြ𝐫𝒄𝒂𝒏𝒄𝐫 and 𝐥𝐸𝐵.
All right. Good afternoon. You can assume that we are familiar with your briefs. We've read them, generally familiar with the record, although in this case we know it's rather extensive. And I'd ask you to focus your arguments on what you feel are the more salient points with that as background. We're generally going to give you about 15 minutes aside. If you want to reserve any time, Mr. Perez, just let us know that up front and how much time you want. And if there are no preliminary questions, we'll begin with hearing from Mr. Perez.
Good afternoon, judges. My name again is Santos Perez. I represent 𝒖𝒏 Applebaum. We are here today because of an opinion, a decision by Judge Bergman dated April 30th, 2019, in which Judge Bergman basically decided that 𝒖𝒏 Applebaum should not be entitled, inter alia, to 40% of a business, a family business, which she built from the ground up with her husband, with whom she had 3 children. A collateral but very significant issue is also the removal of the executor, which was sought by emergent pleadings back in 2014, and then again in 2016 via motion before Judge Stefani, and then again in 2018 by way of 2 motions, which included 1 motion for reconsideration. And those 2 2018 motions were based on compelling testimony by independent bankers, whom basically stated on the record under oath that the fraud that took place in relation to certain loans was material, it was significant, and the motion in 2018 was primarily premised on those 2 depositions, which should have essentially called for the immediate removal of the executor for fraud. The proofs were indisputable. They were not in dispute, and in addition, the 2018 motion was also for removal was also based on thousands of pages of documents, recordings, and including certified transcripts, which included various admissions by Mr. Fabian, in which he very nonchalantly stated that he would place himself on the payroll of the Todd Harris Company to pay himself a debt which goes back about 30 years, which he says began with a $100,000 loan, and subsequently ballooned up to $602,000. And prior to being sued, Mr. Fabian readily and quite often admitted that he was paying himself this debt on the payroll of the company that he wasn't essentially working. He never said, I am working for the Todd Harris company. He basically just said, I have this debt. Mr. Todd Harris Applebaum has died. I need to be paid this debt, and it's going to be paid. He, in numerous recorded meetings, he basically said that his holdings, these debts that he had, these off-the-books debts that he had with decedent, were to be kept out of the eyes of absolutely everyone, that they were not to be disclosed to anyone. He made it crystal clear. And in addition, we have recordings in which he stated, he admitted first of all that these debts, these holdings, were never disclosed to banks back in 2012 before decedent passed away, or back in 2010. And he basically set forth a plan at one particular meeting called the crisis meeting of June 25th of 2013, in which he basically stated that the plan going forward was to basically borrow more funds from more banks, but his debts have to be concealed, because if they're not concealed, then they would not be able to get any loans. This is just one aspect of the fraud that we have in fact, a judge respectfully proven.
Mr. Perez, let me pause you there.
Yes.
Say that we accepted that allegation. How does that play into the estate dispute? And what damage does your client have as a result, do you allege?
Well, the damages, Judge, we began firstly by noting that my client
Mr. Perez?
Yes.
I've read your very long brief. I'm asking a very specific question. You're raising this argument, and it's hard for me to follow how the alleged bank fraud impacts the estate. That's what I'd like you to answer.
Well, the bank fraud, Judge, primarily goes to the issue of removal of the executor. The executor very distinctively, routinely, repeatedly said that his holdings were to be kept off the record. No one was to find out. And, Judge, there is no reason whatsoever to have any faith in a final accounting, which was redacted, for starters. I think it had probably over 60 or 70 entries which were completely redacted. No one knows what those redactions mean. And the proper way to have gone about this, Judge, a more structured way to have gone about this was to remove the executor, appoint an unbiased third-party fiduciary, and for that fiduciary to determine whether or not the company has to be audited, whether or not a special master has to be appointed. But as it stands, it is crystal clear that Mr. Fabian said he's going to conceal his debts. He placed himself on the payroll. He planned to borrow funds by way of a conspiracy to conceal his debts. And this, Judge, which we have proven with via any standard of proof, burden of proof, Judge should have compelled Judge Bergman to remove the fiduciary pursuant to 𝒂𝒏 𝑦𝒔𝒕𝒂𝒏, Judge. And if I may, Judge, very briefly, because my brief did cover removal, but the starting point for removal is the statute NJ3B 14-21. 𝒂𝒏 𝑦𝒔𝒕𝒂𝒏𝒌 cited to a previous version of the same statute, which was codified at Title 3A. That no longer exists. That's no longer there. But 𝒂𝒏 𝑦𝒔𝒕𝒂𝒏𝒌, Judge, a 1936 case, basically set forth that a fraud is not accepted. A fiduciary, sure, he or she enjoys a somewhat of a tenure by having been appointed by the testator. In this case, that can be disputed. But assuming arguendo that he was in fact properly appointed as the executor by the testator, by the decedent, then he does enjoy some measure of tenure, and it is difficult to have him removed. However, Judge, the case law is clear that fraud is not accepted. Now, that begs another question: what is the proper standard of proof in terms of deciding whether or not there was fraud? Countless scholars have cited to 𝒂𝐩𝐳𝒐𝒂𝒂𝒂𝒂𝒂𝒂, in which the court said courts are hesitant to remove a fiduciary absent clear and I think it was clear and convincing proof of fraud, Judge. But that was, frankly, I see that as having been more of a not a holding, but of dicta in that opinion, so that the court did not, the 𝒂𝐻𝒂𝒂𝒂𝒂𝒂 court in 1936 did not necessarily say this is the standard, clear and definite proof, actually, of fraud. That remains up in the air. I've done, the case law that I've uncovered does not clarify what that means. There have been few instances of removal, Judge. Then again, I've not seen any case with the same fact pattern in which we have admissions and we have two bankers, which basically stated, Judge, absolutely, it would have made a difference had these debts been disclosed, had these holdings been disclosed in terms of deciding whether or not the bank would have given any loans to Mr. Fabian. But Judge, primarily to answer your question, the bank fraud is pivotal and it is key in deciding whether or not Mr. Fabian should be removed. And that brings into question another aspect of the case, the Sun Bank lawsuit, which was prevalent, omnipresent throughout this entire litigation, Judge, and that was concealed. And the two bankers said that was significant. In particular, I remember, and Mr. Howard remembers because I took his deposition, one of the bankers for Wells Fargo basically said that he was very adamant and he essentially volunteered the statement, yes, it absolutely would have made a difference had I known about this. It was significant. And a Judge, throughout my client's entire ordeal, she has always been blamed for being uncooperative, for not being a team player, because she refused to give a guarantee to that same bank. So therefore, they blamed her for the bank not having given a loan to the Todd Harris company. Whereas in reality, the banker, Kevin Harvey from Wells Fargo, very distinctively said, look, if I had known that there was a lawsuit against this company, had I known that Mr. Fabian, who is the executor, also has a $600,000 debt, then I would never have given them the loan regardless, Judge. And so therefore it's pivotal from that perspective, Judge. And one further point, Judge, that is that this court should be. I've emphasized it in my brief, Judge. The purported employment agreement used by Mr. Fabian is a complete hoax. My expert, we retained at Friedman LLP, a CPA. They characterized the employment agreement as a phantom stock agreement. In fact, I believe they cited to the valuation of the Grant House valuation of the company, which had referenced the employment agreement as constituting basically some sort of a phantom stock agreement whereby Mr. Fabian and Mr. Rice, spelled R-A-J-S, both basically owned a portion of the company, in essence, off the books. So it's a vehicle. The employment agreement is a vehicle for ownership of an asset, and that agreement, Judge, the purported employment agreement was signed contemporaneously with the 2012 will, and Judge, Mr. Fabian claims that agreement entitles him to be paid his debts, not that it entitles him to work for a living, but that it entitles him to be paid his off the books debts, and he claims that Judge, he started paying himself his debt as soon as the decedent passed away in 2012. He signs an agreement in 2010. 2012 comes. The decedent passes away. All of a sudden, he says, "Oh, I'm going to put myself on the payroll." He doesn't produce the employment agreement yet. Throughout before litigation, he constantly represented to my client, Judge, that he was paying himself, and he admitted this, that he was paying himself a debt. He was not working. He was paying himself a debt. That was never in question. He was never making a real salary. And after he was sued, Judge, he pulls out this 2010 agreement and says, oh, no, I can actually work, and I'm working pursuant to this agreement. The problem is that he also, in a 2014 certification, he also said, well, listen, I'm paying myself this debt. He admitted it in court.
Mr. Perez, I don't mean to interrupt you, but you do have limited time, and we're a court of appeals. So what you need to do for us is identify which orders you're appealing from and the basis of your argument. Re-arguing facts to us is not necessarily assisting us in understanding your arguments. So you've raised quite a number of arguments, and it would be helpful if you identify what you think are the real errors that an appellate court can address for you.
Well, Judge, we can begin with the 2014 orders. There's an issue as to whether or not this was properly raised. I would say that...
Mr. Perez,
yes.
You can begin wherever you want, but you have about 5 minutes of time left.
Sure, Judge.
And what I'm really inviting you to do is focus us on what you think are the primary errors that you want to raise to our attention.
2014, Judge, there was no application of the clear and definite proof of fraud standard. The Judge Safani, unfortunately, applied the standard of irreparable harm only, but he never got into the issue of whether there was fraud. 2016, same issue, Judge. There was a removal motion. The judge, it was Judge Safani at that time. He never delved into the issue of whether or not there was clear and definite fraud. Instead, as a statesman, he tried to craft a compromise, and he decided that the executor should issue quarterly statements and monthly and quarterly statements in order to appease my client so that she can feel comfortable that. But that was an error, Judge, because the proper standard should have been applied in 2016 and 2014, and Mr. Fabian should have been removed. Same for 2018, Judge. 2018 comes around, then we have two bankers who corroborate the extensive fraud proofs. Judge Bergman should have removed this fiduciary. And secondly, Judge, naturally, the issue of my client's 40% shares, no one disputes that the decedent said, specifically decided that he would, in fact, give her 40%. There's collateral evidence by the scrivener of the will wherein he said, Judge, in a sworn testimony, he basically said, Miss Edita Applebaum, I convinced her husband to give her 40%. Sure, there's talk of him, the decedent, having said potentially that he didn't want to give her the 40%, he wanted to give her less. But the point is that everyone agrees that Mr. 𝒂𝒏, the scrivener of the will, convinced Mr. Todd Harris Applebaum to give his wife 40% of the company by way of the residuary cost.
Where in the will do you say we would find that?
I believe it's clause 8, Judge, if I'm not mistaken, and in the will, it's clause. The residuary clause. The 5th clause of the will is a specific bequest of 60%, and then the 6th paragraph basically states, and I quote, Judge, should my beloved wife Edita survive me, I give, devise, and bequeath to her all the rest, residue, and remainder of my estate. And Judge, the case of In Re Estate versus Howard, I just want to point out very briefly, that case basically said that the will in that case was similar to the will in this case, in that the executor had discretion to decide whether or not he would distribute in kind or in cash. The court in Re Estate of Howard was very clear in stating that subsection 1, which is the one that Mr. Howard subsequently, after I argued the case in before Judge Bergman, adopted, that it doesn't apply because the residue of the estate, the residuary, is not a specific bequest. It's a general bequest, so therefore subsection 1 does not apply. And this is Mr. Howard's argument below, because he first said that subsection 3, and I'll quote exactly if this court wants me to quote it's 3B3-33.1 and 33.3, but make sure I have this correct, Judge. No, I think I have that citation wrong, but it's actually 3B23.1 and 3B23.3. And the In Re Estate of Howard Hope Court basically said that subsection 1 does not apply. Mr. Howard below, during oral argument, first said that subsection 3 applied. Then he said, well, no. After I argued the case, he said subsection 1 applies. And Judge Bergman purportedly premised his decision on that subsection. The problem is that In Re Estate versus Howard Hope was very clear in stating that subsection 1 does not apply. This is not a specific request. It's a generalized, it's the residue of the estate. So therefore, this takes us to the applicable statute, which is subsection 3, 3B23-3, which basically says that there has to be an objection before a in-cash distribution could be allowed. And the issue would be, Judge, whether or not a trustee can object, whether or not a fiduciary can object. In the case of In Re Estate versus Howard Hope, it was clear that the court said that the only person who's allowed to object is a co-beneficiary of the specific asset. In this case, the only beneficiary of the residuary of the estate is Adita Applebaum. So they had no facts, they had no law to impose this drastic death penalty remedy on a widow who had been virtually arrested in the beginning because they were afraid that she would be a whistleblower, and she was fired from the company. Respectfully, Judge Bergman got it wrong on the facts. He got it wrong on the law. The New Jersey, the In Re Estate versus Howard Hope Court premised its decision on the UPC, Uniform Probate Code Section 306, and they were very clear in stating that, look, this is New Jersey has a preference for in-kind distribution. There's got to be something big, something special. And the problem in this case is that there is no case law which says this is something special. There are no facts. There are no proper objectors who can basically say that she should not receive in-kind distribution of the shares. And to the extent this court is inclined to say that the case law supports the proposition that the fiduciary can object to distribution, that would be a case of first impression, Judge. That would be, and I don't see why a lawful spouse of a decedent should be disinherited in this manner, in this grotesque manner, particularly, Judge, when all she did wrong was become a whistleblower because the company had been sued by Sun National Bank, and because the decedent, that Mr. Fabian, never denied that he placed himself on the payroll. He never denied that he increased Mr. Rice's, the RAJS salary immediately after the decedent passed by $50,000. So there was a lot of waste and a lot of activity going on. My client then just wanted to sit by. So she did her due diligence and she consented. She obtained the consent of all parties to record every meeting. Every meeting was recorded, and we have the proofs. Their admissions, Judge, their lawful admissions, the judge below should have never disinherited my client. He should have awarded her damages for the sale of the Tobin property. He should have awarded her damages for the misappropriation of her $100,000 401k plan. They took that as well. So my client has gotten nothing except the marital home.
All right. I think you're at a point where you've used up your initial time. Mr. Howard, we'll hear from you.
Thank you, Your Honor. The fundamental problem with Mr. Perez's entire argument is that he's never managed to produce any evidence to support it. He seems and he's done it again today, he did it with Judge Bergman every time he appeared before him, to believe that by shouting the word fraud, perhaps putting it in blue ink in his brief, putting it in capital letters, that somehow is the equivalent of proving it. I respectfully submit it's not, which is probably why Mr. Perez never answered your question, Judge Gilson. And that was, what were the damages? And the reason is that even if you gave credit to Mr. Perez's mischaracterization of what happened, there were no damages. There was also, and he hasn't bothered to attempt to show damages, and he hasn't bothered to attempt to show reliance. He hasn't bothered to show that anything was actually concealed from him, which is the very problem that Mr. Perez encountered in October in the district court, United States District Court, where he has a parallel lawsuit going on out of this litigation, in which his attempt to amend his pleading to assert additional claims of fraud was denied as futile, because none of it is backed up by any of the accepted requirements for proof of fraud. The same here with this digression
for the parties in the federal action.
I'm sorry, Your Honor?
Or the parties in the federal action.
It is, I don't have the pleading in front of me, but it is Adita Applebaum as the plaintiff. I'd be happy to supply the decision to the court. I didn't in advance because when I read the requirements for unpublished opinions, I couldn't very well say that a motion denying leave to amend would constitute, would meet the res judicata or collateral estoppel standard.
I guess my broader question is, how do we have two lawsuits going on at the same time?
A question I couldn't even begin to answer, Your Honor. I know Mr. Perez saw fit to attempt to add me as a party to that lawsuit, which I believe is now was denied, but he's now appealed to the district judge. So my understanding is it's pending. So there is.
Has there been an accounting of this estate?
An accounting?
Yeah.
Yes, that's what Judge Bergman accepted in his April 30th, 2019 decision.
Where do we find that exactly in the record, the actual accounting? That
would be in, we have 9 volumes. I don't have all 9 volumes in front of me. I have to look in the computer to find them, and I'm using the computer now. But it would have been, well, I can tell the court. It was the order to show cause. The executor's final account appears at A1298 to A1372.
Thank you.
Sure. So we have Mr. Perez citing a few of his facts, supposed facts, to support his claim that there was fraud. And I want to go through them. I know I've talked about them in the brief. I will try to be as quick as possible in going through them. The first one is about the bankers' depositions, and we've talked about that. He cites the one banker who had no idea even what Mr. Fabian's involvement was, because the last time she was involved was in 2010, and she was involved with the decedent, not Mr. Fabian. So that's pretty well a non-issue, and her testimony is irrelevant. And the second one, this Mr. Harvey, Mr. Perez has misrepresented what he said. He did not say anything like what Mr. Perez said. What he said was that the reason that the Wells Fargo loan was not made was because he was told that Adita Applebaum would not guarantee the loan. There's nothing substantive in either of those depositions related to Mr. Perez and his client's allegation. Then we get to this thing that Mr. Perez calls payroll fraud. We have an employment agreement Now, Mr. Perez can have all the personal opinions he wants, but they're not evidence. The fact is the employment agreement has never been shown not to be authentic. There's been no evidence even suggesting it's not authentic. It is signed by Todd Applebaum. It was not done the same day as the will. It was done a month before the will was done. And on the same day, Mr. Applebaum signed an employment agreement with Frank Rice, which is roughly comparable to the one that he signed with Mr. Fabian. And the employment agreement, which Mr. Fabian has testified at length, we've gone through it at length in our brief, how this came about. He was taking a salary based upon the agreement that he made with the decedent. And for that, as he also testified, he provided regular services, and as he also testified, he was not repaying any loans, and he has never been repaid on the loans that he made to the estate, or to the decedent. And to this day, he has not been repaid on those. Then we have a plaintiff relies upon the Sun Bank issue. Yes, there's no question about it. Sun Bank did bring suit. But the only testimony that shows what actually happened is what we've put in our respondent's appendix, which is at DA 30 to 31, and those are the interrogatory answers by the company's bookkeeper, who is the person who drew down the line of credit that prompted the filing of the lawsuit by Sun Bank. No one has ever contradicted her. No one has ever suggested she wasn't telling the truth. And what she said was, I made a mistake. Mr. Fabian didn't know about it. Mr. Rice didn't know about it, and I'm sorry. And that's pretty much what happened. She did exactly what she had done for Mr. Applebaum, which was to sign his name to a drawdown. She didn't know there was a personal guarantee by Todd Harris Applebaum. She didn't know that what she was doing was something that would inflame the bank, which it did. And how was that resolved? Mr. Fabian, out of his own money, loaned $360-some thousand, personal money that he took out of his personal bank account, that he loaned to the company in return for a mortgage that he did so the company that had been run by his best friend would survive, which it did. So instead of being thanked for what he did, all he has received from Mrs. Applebaum and her counsel is attack, and charges of fraud that are totally unjustified. As I'm sure the court appreciates, paragraph 8 of the will specifically empowers the executor to decide whether distributions are to be made in cash or in kind. Yes, there is a preference in this state for in-kind distributions if that is possible. But there is also the statement made so long ago in the Hazeltine case, which was a court of prerogative writs, and I'm not sure where that fits in the hierarchy of courts in this state. But the court did say that the first place you look to see what the authority of the executor is the will. And if you look at the will, Mr. Fabian had that power. And what he also describes in the various certifications and testimony he gave is that Mrs. Applebaum was totally unsuited to employment at the Todd Harris Company, and that if she had remained in that position, she would have destroyed the company. And if she destroyed the company, it would have destroyed the inheritance that Todd Applebaum wanted to leave to his children. And if you look at it, he left 60% of the stock to be held in trust for the benefit of Mrs. Applebaum during her lifetime, but also for the benefit of the children for their entire lives, and upon her death, the remainder would go directly to them. The other 40%, he was convinced to put in his will, but he put it in that it would be up to his friend, trusted advisor, and executor to decide what was going to happen in the end, and he made that decision. There's no disinheritance here. Your Honor, Judge Bergman got it right. And before him, Judge Schifani got it right. They should be affirmed. Thank you.
All right, thank you. Mr. Israel?
I'm going to be very brief because I frankly can't tell what, if anything, brought by the appellant impacts Mr. Rice at this point. There was a reference to a 2014 order. Back in 2014, when this case was first filed by Ms. Applebaum's first of 3 lawyers, the impetus was to remove the board and the officers and directors of the company. It was not focusing on the estate issues at that point. Mr. Rice was both on the board and was an officer and therefore was a party to that. The only issue on that order that I've heard is that Judge Schifani did not apply the appropriate standard. He applied 𝒂𝒃𝒂𝒂𝒂. That should be the end of the discussion. It was properly applied. Other than that, the only reference I've heard to Mr. Rice is about his employment agreement. And not only to the employment agreement, more the fact that he just had his salary raised after Mr. Applebaum died. And the reason for that is because Mr. Rice took on all of Todd Applebaum's responsibilities. This company had been run by Todd. I have no idea what Mr. Perez is talking about when he says that Adita built the company from the ground up with her husband. That is just an outright falsity. Not only did she have nothing to do with the company, but the record shows that Todd didn't want her to have anything with the company. So this was Todd's company. His will directs how it was supposed to be applied. And all of the orders, whether they were from 2018 or on, having to do with the estate, has nothing to do with Mr. Rice because he's not an executor. And I think Mr. Howard properly addressed those issues. So unless the panel has any specific questions of me, I intend to relinquish the rest of my time.
I don't have any questions. Thank you.
Nor do I. Thank you.
I don't have any. Thank you.
All right, Mr. Perez, we'll hear you in reply if you want.
Thank you, judges. First of all, Judge, Ms. Applebaum raised the decedent's 3 children. To call that nothing is an affront to everything that's called dignity. Mr. Applebaum did not do that. It was my client who raised these three children, and therefore she did 90% of the work that allowed Mr. Todd Harris Applebaum to build that company. So she did almost everything. 90% of the work. Raising 3 children, I would say so, Judge. Secondly, the impetus for and the relevance of Mr. Rice is that in August of 2013, Mr. Fabian admitted basically that Mr. Rice agreed with him that he should pay himself this debt, the $602,000 debt, for which he has no proofs by placing himself on the record on the payroll of the Todd Harris Company. And Judge, this court should know that Mr. Fabian admitted in his interrogatory answers that he did not engage in the payroll scheme in 2011 because of an IRS audit. Now, this is what I call open concealment. You put something out there that's clearly, and we've seen plenty of that as of recent, Judge, but you put something out there that's a clear fraud, something that is untrue, and you waltz around and pretend nonchalantly that you're doing nothing wrong. And you get away with it. Some people will believe you. But that is not the case. Mr. Fabian committed fraud. He knows he did. The employment agreement is a hoax. There's no other way to characterize it. There are recordings which Mr. Howard is aware of which say that, which prove that Mr. Fabian said he's paying himself a debt on the payroll. He is not working. The employment agreement doesn't come into play. The employment agreement doesn't say, hey, you can pay yourself these debts, whatever you think they may be at some point in time when I die, by putting yourself on the payroll. It does not say that. All it says is that if you work, you're entitled to money. but they're misrepresenting this over and over again. And Judge, the elephant in the room, the federal case, I respectfully, and yes, there's a motion to include Mr. Howard. I know this is scandalous, but Mr. Howard saw it fit to sign a certification stating 3 times that the Sunbank lawsuit was never filed. The Sunbank lawsuit was premised on forgery by the executor and by other people involved, and by doing so, Mr. Howard thrust himself in the middle of a dispute as a fact witness. He did a brief research, if you will, searched an outdated New Jersey court's electronic portal. I think it's ACMS, which I don't think it's even being used today with e-courts. And he did a search for the Todd Harris company, not for the executor, not for the estate. No, he did one single search, Judge, one for the Todd Harris company, didn't find anything and said, oh, it hasn't been filed. The problem is that he has been in this case for about 5 years. He knows it was filed, Judge. He stood before Judge and before he was present at all depositions, and Judge, he was also aware. I was there. He also saw when Mr. Kevin Harvey distinctively looked up very emphatically and emotionally said, almost in an apologetic way, said, absolutely, it would have made a difference if you had disclosed this. He didn't want to say that. He did not want to, and Mr. Howard knows that, and Mr. Howard knows that he said that, and he misrepresented that to this court right now. But Mr. Kevin Harvey did say that. Absolutely, it would have made a difference, and I'm sorry, guys, that I have to say this, but I'm not going to commit fraud. I'm not going to be a part of this. So he said it. It was a material omission by some of the parties involved. And likable as they are, because Mr. Gold is a very likable person. He's the CPA, whom I have not been able to depose yet. Unfortunately, my client stands now with 0. She was forced to put her youngest daughter, decedent's daughter, through college without 1 penny with her school teacher salary. And meanwhile, the whole world is gaslighting everyone else around them and saying, well, she's the devil. No, there are clearly culpable people here, Judge. The end result is evidentiary in terms of my client having received nothing. So therefore, there's something wrong here. Houston, we've got a problem, Judge. So I would ask that this court overturn or vacate the decisions regarding removal of the executor, for the court below to appoint a new fiduciary, for the accounting to be vacated, Judge, and for her to get a proper accounting of everything that happened. And unfortunately, Judge, I do take issue. No one is perfect. Everyone makes a mistake. Everyone will utter once occasionally a word that may be improper. But Judge Bergman, he basically called my client's certifications useless, and he said that they were fake news. And in the meantime, he would sua sponte. He would pull up if I said something about fraud. Well, Mr. Fabian said this. He said he's paying himself on the table. Then he would say, well, then he certified that he did not do that after he was sued. So he would pull up that Mr. Fabian's certification and say, this means something, but he explicitly called my client's certification useless. This is an affront to everything that I know. There were no decisions in this case. Judge, if there were 30 decisions, they all went in favor of the executor. To say there was bias is an understatement in this case. So I respectfully will request that Judge Bergman's rulings all be overturned, that my client get the opportunity to have a new fiduciary, and that she be allowed to get a proper accounting of the status quo of her husband's company, and for the court below to decide whether or not there should be some further financial review of the finances of the Todd Harris company and the estate. Thank you, judges.
All right. Well, thank you. We appreciate everyone's presentation today. We'll take the matter under consideration and get you a written opinion in due course. Hope you all have a nice day and a good week. Thank you very much.
Thank you.
Thank you, Your Honor. You too.